I'm taking notes on that. Patton's present and sitting to my right this time.
Mr. Patton is scheduled for a preliminary examination today. And we adjourned this previously because additional discovery was being sought. Did you get your discovery?
Yes, Your Honor, we did receive, we requested the affidavit. We also requested body worn camera. To my knowledge, we've not received any sort of body worn camera at this time. However, we did receive the affidavit for search warrants.
What's the status of the body cam?
Your Honor, I would have to look into it. I'm not sure why the defense hasn't seen the body worn camera, or hasn't received the body worn camera. I think I said seen. But I will definitely look into it and make sure that he gets it immediately. I did put in a request, so I'm not sure what the issue is there.
And the only thing, Your Honor, I would say is because there's several agencies involved, I don't know if it's going through a different means than usually get it through evidence.com, a link. But I mean, at this point, we don't have any of the body camera, but I don't know if it's just brought in differently. However, my understanding is that the people wouldn't even be prepared to proceed today if we did have all the evidence.
Is that correct?
That is correct, Your Honor. That being said, it's
Why?
my first priority to make sure that the defense has their discovery as soon as possible. So I'm going to look into this today and make sure that Mr. Mills gets what he needs.
Why aren't people prepared?
The people are unprepared at this time, Your Honor, because unfortunately our main ATF officer on this case, his child had an emergency surgery yesterday. He was planning on being here. We've been in contact. He's been very participatory, but I did get an email yesterday afternoon that he was going to be unable to make it because of his family emergency.
All right, so
If I may, Your Honor.
you may.
Thank you, Your Honor. Your Honor, the fact that he's heavily involved here, I think it runs a little hollow. When we were here last time, no one from ATF or anyone else showed up, despite being subpoenaed. I believe we had one officer here, and the people were not able to proceed at that time. The only reason we agreed with an adjournment, despite people I don't think being ready to move forward at that time either, was because we did want some of this additional information. So I don't know what the officer is saying at this point regarding he really wants to be here. He's already demonstrated his not.
I can understand your concerns. At least it relates to the first failure to appear. I don't know why they would not be present.
There was an ATF officer here, I believe, according to my notes. Officer Arnold was here. That is his, I believe that we needed one or the other was the situation.
Okay, last time you said one, so you needed one or the other, and then why can't we move with one or the other this time?
Because after looking into it further, Your Honor, that is not true. We need this specific officer. So that's my apology for that.
Okay, sounds good. Okay. Under the circumstances, it's outside of the officer's control that his child had an emergency surgery yesterday. I'm going to grant the request for an adjournment. Also, positive. This is a matter that the people would reissue if I dismissed it, correct?
Yes, Your Honor.
So this is going to be reset. July 17th.
Just for the clear record, Your Honor, Detective Arnold is LPD.
I must be getting the name mixed up. It also starts with an A.
No, that's Detective Arnold, but he's with LPD, but he's embedded with a task force with ATF.
So it's complicated.
Can you state your name for the record?
Yes, I apologize, Abigail Wilson for the
Sorry.
people.
Thank you. I don't know. I couldn't tell you what Detective Arnold does. So I'll rely on what they're saying. Either way, the officer they claim they need is not here today due to a family emergency. However, they'll have their officers here next time where the case will be dismissed.
Understood, Your Honor.
July 17th at 9:30. July 17th at 9:30. And then you should have your discovery well before then, because I set this out. Well, even April 11th, there was a concern about additional discovery being sought. April 17th, I was told additional discovery, including body cam, lab reports, and search warrants. were being sought. And so here we are a month later and you've not received them. So they need to be turned over immediately.
Just, and Your Honor, if we don't have everything we need at that time, understand that that information is there. I'm going to be moving for dismissal based on violation of discovery at that time.
Absolutely. Any additional matters for the record?
Not on behalf of the people, Your
What's
Honor.
it, 17th?
The
July?
17th, does that work for you?
Yes, 17th at
9:30.
9:30. Thank you.
9:30.
Thank you very much.
No problem. Do you know if we're running Gil?
Yes, sir.
Okay, sounds
We are.
good.
I mean, 3 witnesses, and might run a little longer.
I saw Mr. Freeman. Is he still here? Oh, okay. Mr. Freeman? Do you have Hayes here? Oh, Donnie Seaton. Do you have Donnie Seaton?
I have them. Yes.
Okay. Are we running that?
No.
Okay, on the record, in the matter of the state of Michigan versus Donnie Seaton, 24-03053, appearance, please.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
I'm sorry, I'm confused. I beg your pardon. I haven't spoken to this gentleman.
Is he here?
That's my understanding. I thought we were talking about a Mr. Hayes.
I did ask about Hayes and then I asked about Seaton. Which one are you talking about?
I have Mr. Hayes right here.
Okay, have you spoken to Donnie Seaton?
I've spoken to the prosecutor, and yes,
Is Donnie Seaton here?
I don't know.
Mr. Seaton called and said he didn't know he had to be here.
Oh, okay.
In
Mr.
person.
Seaton's not here yet, then it sounds like. Okay, so you're ready on Hayes?
Yes, Judge.
Okay, on the record in the matter of the state of Michigan versus Valari Hayes, 23-02554 and 23-02495, appearance, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. Stephen A. Freeman, Assistant Public Defender, on behalf of Defendant Hayes. Thank you.
Thank you. Mr. Hayes has 2 files, both scheduled for preliminary examination, controlled substance delivery, manufacturing, and delivery, manufacturing of drugs, and then a controlled substance 3 counts in the other file. How are we proceeding on these?
Thank you, Your Honor. It's my understanding, I wasn't here last week, but that Mr. Palmer requested leave that's set for to treat today as a PCC because he hadn't had a chance to control his time very well. And so we're here today. I spoke to Mr. Freeman. Mr. Palmer is out. So I believe Mr. Freeman is going to request a waiver for 21 days and have the matter reset for preliminary examination so that Mr. Palmer can further speak with the defendant, but I will defer to Mr. Freeman for fear that I'm saying something incorrect.
The note that I have, I wasn't here last week either. Judge DeLuca presided on this matter in my stead. The initial note was to treat it as a PCC, but then he put another note. Defendant appeared by Zoom. Mr. Palmer now decided to continue to exam. So we're not having an exam?
That's correct, Your Honor.
Mr. Palmer's not here?
Well, no, not standing alone, but his absence does create other problems. I'm not going to divulge in a public setting. I'd be happy to tell the court privately, but there's been some discussions about other ways to resolve the case than simply having a hearing or having a trial.
Oh, so there's negotiations pending on resolution?
Yes.
Okay.
yes.
Is that?
Yes, I
Okay.
had sent an email to Mr. Palmer with a possible resolution. Apparently he's out of the office now.
Okay, and then is that gonna be a global resolution? That's the both files?
Yes, Your Honor. It would be.
Okay. It looks like we are, on the 23 file, Mr. Hayes has already waived the 21 days because he failed to appear previously. And so he's willing to waive the 21 days today.
That would be our intent, Judge.
Is that correct, sir?
Yes.
Okay, so you understand you have the right to have your exam within 21 days of the date that you're arraigned?
Yes.
And because you are negotiating a global resolution, you're willing to waive the timeline? So I can reset it?
Yes.
Okay. July 18th at 10. That's for both files. We are gonna get you a notice to appear while you're here today. But if you lose the notice, it's for your responsibility to stay in communication with your attorney, who's Mr. Palmer, on both files, correct?
Yes, I.
To stay in contact with your attorney and to appear to all your court dates, okay? Yes,
Yes, I have been trying. They say he was sick out last week. I've been calling since I, been out. I haven't got a call back.
I believe if they said he's sick, I believe he's probably not well. So, I'm only reminding you because you have failed to appear previously, and then you gave the excuse that you didn't get a notice to appear, but we would have given you your notice to appear while you were present. Because I had a note here on 2023, defendant has a new file, and the defendant was supposed to turn himself in on a warrant. And so I reset this to October 5th, and you didn't turn yourself in on the warrant. So that's why, and that would be this file. So that's why you didn't get a notice to appear, because you were supposed to turn yourself in for the warrant. Okay, but it's your responsibility to keep up with your court dates, okay, sir?
That's what I'm-
Okay, so we'll get you notices on both files, July 18th at 10 a.m. Do you have any questions?
No, ma'am.
Any additional matters for the record?
Not on behalf of the people, Your Honor. Thank you.
Nothing further, Your Honor. Thank you.
Thank you. So let me make sure I'm understanding. Is Mr. Sino? Okay, on the record. In the matter of the state of Michigan versus Charles Gill, 25-00958FY. Appearance, please.
Good morning, Your Honor. Jennifer Lawton on behalf of the people.
Good morning, Your Honor. Stephen Mills on behalf of Mr. Gill. Mr. Gill is present and seated to my right.
Okay, Mr. Gill was scheduled today for a preliminary examination on one count of kidnapping. Let's see, 2 counts of criminal sexual crime, 3rd degree, police officer, fleeing, controlled substance possession, a CSC 4, and habitual offense notice. How are we proceeding? You can stand.
Your Honor, it's my understanding that both the people and the defense will be unconditionally waiving their right to exam today. However, that will be to an amended complaint. And I guess what I'd like to do is just kind of walk through each count with the court, just to make sure that we are clear on everything.
Okay.
So count 1, kidnapping, would stay the same. Count 2 would be dismissed. Count 3 would be dismissed. Count 4 stays the same. Count 5 stays the same. Count 6 stays the same. For some reason on the complaint, the habitual offender notice is labeled as a count 7, and it shouldn't actually be a count. So I would now then move to add a count 7 of criminal sexual conduct in the 1st degree. Yeah, count 6 stays the same. Count 7 is going to be an added count because it should not be habitual offender.
Yeah, someone crossed it off on mine, so they.
Okay. So count 7 will be a CSC first under the theory of multiple variables. That is MCL 750.520B with an added second offense notice under 750.520F. Add a count 8, CSC first, multiple variables under MCL 750.520B with a second offense notice, 750.520F. Add a count 9, felony firearm under MCL 750.227B/A. Add count 10, felony firearm, MCL 750.227B/A. Add count 11, felony firearm, MCL 750.227B-A. At count 12 felony firearm, MCL 750.227B/A. At count 13 felony firearm, MCL 750.227B/A. At count 14 felony firearm, MCL 750.227B/A. So counts 9 through 14 should be felony firearms, and those would attach to all of these subsequent felonies that are charged.
Okay, just to reiterate, we're discussing counts 2 and 3. All the other counts will remain intact. At count 7, criminal sexual crime in the first degree under the theory of multiple variables. The second offense notice attached to that. At count 8, CSC first, again, under the theory of multiple variables. And a second offense notice on that, counts 9 through 14 felony firearms.
And Your Honor, if I may.
You may.
Thank you, Your Honor. First and foremost, it's also my understanding that people are not going to be seeking additional charges regarding CCW or other charges along those lines at this time. With the way for the bind over here, Your Honor. I'd also like to inquire of my client if that's okay, Your Honor.
You may.
Thank you. Mr. Gill, I'm just going to ask you a few questions real quick, okay? Now, you and I had an opportunity to talk regarding your rights to a preliminary exam today, right? Yes. And the judge is also going to ask you these questions. I understand that too. But we did talk regarding your right to run it or even the opportunity to waive the preliminary examination. Is that right?
Yes.
And I informed you that, the people would be seeking additional charges. Is that correct?
Yes.
And we had the opportunity to speak regarding your rights even after all of that. Is that correct?
Yes.
Did you have enough time to ask me questions regarding potential bind over versus running the preliminary examination?
Yes, I did.
And it's my understanding that even with the people adding this charge, you'd still like to waive your preliminary examination. Is that right?
Right.
Now, if you have additional questions, did you have the opportunity to ask them?
Yes, I did.
But you feel like you understand what's going on and the
Yes,
circumstances here?
Yes, explain everything to me.
Okay, just want to make sure. Thank you, Your Honor. Appreciate it.
So again, Mr. Gill, you heard the charges that are proceeding to the circuit court, correct?
Yes, ma'am.
And you understand the purpose of the preliminary examination is for the prosecutor to first establish if they have sufficient probable cause that the felonies alleged were committed, and then probable cause sufficient to charge you as the individual who committed those felonies, correct? You willing to unconditionally waive your examination? You understand that once this matter is waived, you can't go to the circuit court, decide that you want to hold your preliminary examination. You understand that? Is anyone threatening you to waive your exam? Any promises if you waive your exam? Okay, the bind over date on this is going to be May 28th. That's the date the circuit court gets the file from the district court, not a date that you need to appear in court. You will not have a court date until they set your pretrial, unless Mr. Milks is filing a motion for you to be rearranged in the circuit court, okay? Do you have any questions at this time? Okay, bond in this matter was set at $250,000 cash surety with GPS tether, victim notification if possible. and you need to report to pretrial services within 48 hours of any release from custody. That will continue. There's also a no contact order between you and the alleged victim. Any additional matters as the bond will continue.
Nothing else from the people.
Just regarding, as part of the waiver here, I think my final one, we just to inform the court that as negotiations will be going forward here, we obviously didn't want to put anyone through testimony or have to take the stand, Your Honor. We're just hoping that that is reflected at least regarding negotiations. It's nothing for the court here, but we just want to place it right now, Your Honor. Thank you.
Thank you. You're all set.
Thanks.
Thank you.
If you see Mr. Freeman in there, you can tell him to come inside the courtroom.